Well, hey, Adam, I want to say thank you for coming in. I know the class appreciated it. We learned a lot. And it's always good to have an expert in the Constitution come in. You know, being the government teacher, I do know a lot about the Bill of Rights, but obviously not as much of the nuance as you do. So I really appreciate that.
My pleasure, Mr. Lindquist. I very much enjoyed it, and thank you to you and your students for having me in. It was a great time.
Well, all right. So we got to talk about the First Amendment cases in class, and I have a couple more First Amendment case questions that have been brought up by a few of you students that I want to ask Adam, and then we'll jump into the Sixth Amendment, some Seventh Amendment, and then mostly some search cases here. So first, Adam, freedom of speech is pretty broad, but can it, if someone makes up a lie, post it all over social media, post it and destroy somebody's reputation, are there any protections for people who had their reputation destroyed or something like that? What is the standard for libel and defamation laws?
Absolutely. That's a great question. So defamation is essentially where you make up a lie and then disseminate that lie, say that lie to a third person. Slander is defamation by sound. It's where you speak it. Libel is defamation by sight. It's where you'd write it down and like write it in the newspaper, for example. So the standard for an average person, a private individual, is simply that you make a statement, it's not true, it has a detrimental effect on that person's reputation, causes that person damages. That's basically all you need to show for a private person. However, there are also occasions where someone who would be defined as a public figure or a public official pursues a defamation claim. So a public figure would largely be someone like a celebrity, like a Brad Pitt or a Britney Spears, or a public official would be a government figure, like a Joe Biden or a Donald Trump.
So you brought up damages. Are you talking like, would that be the Seventh Amendment as well, like suing for damages? Do you have to prove something?
Correct. So if you are able to show that you were defamed, you might be entitled to damages, but in order to justify your damages, you need to establish the ways in which you were harmed. Otherwise, you might only get nominal damages, like $1, for example. Now, but if you have suffered true harm, like, for example, this lie, let's say this lie has caused you to suffer loss of business opportunities. Under that circumstance, if you can establish that, had it not been for this lie, I would have gotten these business contracts, then you could potentially gain the money that you lost for those business contracts. Or if you suffered some kind of mental anguish, you had to go see a therapist, potentially you could get money even for pain and suffering if it's been caused by the lie. And so in regard to public officials and public figures, the public is given much more room to make statements about those individuals. And that's just something that's developed over our appellate cases in this field of law. So one of the primary rules in this field is that a public official or a public figure cannot successfully pursue a claim for defamation unless they show that the person either knew that what they were saying was a lie or that they recklessly disregarded the possibility that it could be a lie. So, if the person knows it's a lie that they're sharing about this person, then that obviously is not allowed. The recklessly disregarding would be like spreading a statement without checking up at all, without doing any effort to make sure it's true. Mm-hmm. And if you do that, you could be determined to have recklessly disregarded the truth or falsity of it.
What about like opinions? What if you say like Mr. X is an idiot?
That's a great question. So opinions are generally going to be protected. Mm-hmm. So opinions are protected. Facts are not. So if you say Mr. X is an idiot, then that is generally going to be protected, and that's not defamation because it's your opinion. However, if you say Mr. X is a thief, that is not an opinion, even though that might be what you think, because that can be either proven or disproven. You know, whether someone's a thief is an empirical fact when you get down to the core of it. And so when you accuse someone of wrongdoing in that regard, that's not protected, especially if it's a false statement. There's also a concept called defamation per se. And defamation per se means if you accuse someone of a crime and they are not guilty and you lied about that, then it's presumed that they've suffered damages. So they actually don't even need to prove damages. All you need to show is that what the statement that was made was not true. So, for example, like if you take an extreme example and you say Mr. X is a murderer,
Wow.
and that's not true, that's defamation per se. Where as soon as you have been shown to make as soon as it's shown that the person made a statement that was a lie, damages are presumed.
And so you might win in court, but you have to prove how much you would have lost because of that.
Right. Exactly.
And that's a tough standard. I see.
Exactly.
Okay, I want to move to the Sixth Amendment a little bit. And Sixth Amendment talks about a speedy and public trial, but as some of you have pointed out in class that, our judicial system is slow, it seems. So what do they mean by speedy? Is there a legal standard for speedy trial?
Yes, there is. So it depends a little bit on the civil and criminal context. In the Sixth Amendment, we're talking about the criminal context. And so Michigan has a statute called the Speedy Trial Act. And under Michigan statute, which takes into account the Sixth Amendment, the general rule would be 180 days, so 6 months. Generally, within 6 months from the date you're charged with the crime, you're supposed to be given an opportunity for a trial. Now, there's been an interesting sort of interplay between that and COVID, which has largely shut down the courts. And largely, most counties have not been able to hold trials. And so it'll be interesting to see how those cases develop if the defendants claim, well, hold on a minute, I've been denied my right to a speedy trial. And the response of the court or the prosecution, of course, will be, well, we've had no choice because of this pandemic. But absent, these sort of external, really extraordinary forces like COVID, 6 months or 180 days is generally thought of as the rule.
Well, that's interesting. You might have regular cases that would have never gone to the federal court or to the Supreme Court, and now because of this delay, now you might have a Sixth Amendment case against somebody. Now, that kind of leads to, let's say you get taken in on questioning. You're accused of whatever, theft, let's say, and you took Mr. Lindquist's class, so you know that you have the right to an attorney and the right to remain silent, and so you say, I want a lawyer. Do the police have to stop questioning after you ask for a lawyer, or can they continue questioning and say, okay, a lawyer's coming, but we're going to keep asking you until your lawyer gets here because your lawyer's a little bit late? What is the standard there?
It's another great question. So once you invoke the right to an attorney, you're being questioned and you say, hold on a minute, I don't want to answer any questions, I want an attorney. At that point, questions are largely supposed to stop. And the rule is that the police are no longer able to ask any questions or make any statements that are likely to elicit an incriminating response. So the police can ask you if you want a drink or if you want to use the restroom, but they're not allowed to make statements that would sort of bait you into making an incriminating response. The case where that rule came from is called Innis versus Rhode Island. And in that case, a person was running away from the police, had essentially left a shotgun in a field, was arrested, and before he could be questioned, he said, I want an attorney. I don't want to answer any questions. On his way being transported in a vehicle back to the police station, the police were discussing the issue, and they said, yeah, it's too bad that shotgun's out there because there's a school for disabled children nearby.
Oh, no.
And it'd be a shame if one of those children found that shotgun.
And they were just talking amongst themselves.
Correct. Not talking to the defendant or not talking to the accused person. They were talking to the other police officers. But the accused person was overhearing this. And so overhearing this, he decided to volunteer the information of where the shotgun was because he did not want it to be found by a disabled child.
So the guilt got to him. Now, there actually was a school?
Yes, in that case there was. But later on, they used that evidence against him, that he knew where the shotgun was. And he then filed an appeal, and he claimed that, hey, that was illegal for them to say that around me because I said that I wanted an attorney. And his argument was they only made those statements regarding the disabled children to try to bait me into providing information about the case.
And the court ruled?
So the court actually ruled in favor of the police and ruled that those statements were not likely to elicit an incriminating response. But that is where we got the standard. So basically, the short answer is that police, after you request an attorney, police may no longer question you and may no longer make any statements that are designed to get you to say something incriminating.
It is interesting that, just because you have the right to remain silent, and you've seen this in enough court shows, doesn't mean you necessarily will remain silent.
Correct, absolutely. And
So-
it's actually something that's pretty rare, and a lot of times the folks don't invoke that right before they make statements.
Now, question, what what if a police officer, what if he searches my car, I don't give consent, and it turns out in court, I win in court, and they know that my rights were violated, my Fourth Amendment rights were violated, everybody can agree with that. Does that officer get any punishment? Does he have any criminal punishment, or is it just like, whoops, sorry?
Yeah, that's a very good question. So the short answer is, barring something unusual, the officer personally, him or herself, would not suffer any consequence largely. Would not suffer any criminal charge or anything like that. You know, there might be some kind of an administrative action like training or something like that. But this is where we get into the concept of governmental immunity.
Okay.
And so employees of the government, such as a police officer, largely have immunity from criminal and civil penalties unless they know what they're doing is a crime.
So that means they won't be punished later on.
Correct.
Okay.
Unless they essentially know for a fact that what they're doing is a crime and they nonetheless choose to do it anyways. But as long as they're basically operating with using their best judgment,
okay,
they're going to be protected and they will not be punished later on.
Okay, so a little bit, the police are given a little bit of higher judgment in that standard than, somebody else would be. Okay.
Yeah.
All right, let's get to the search cases, because I know that's what we would normally be talking about, and we normally go through like 4 or 5 actual Supreme Court cases to talk about these standards. But before we do, we're not actually going to go through the cases specifically, but question for you is the Fourth Amendment talks about no unreasonable searches or seizure. What is considered reasonable? And then they have the term probable cause. Okay, what is reasonable and what is probable cause? Could you talk about that maybe?
Yeah, absolutely. So the Fourth Amendment generally does not allow a search or a seizure to occur unless certain conditions are followed. So number one, you could give consent. So anyone can allow their items or their possessions or their home to be searched. So that's an exception. Number two would be if you have a warrant. If the police have a warrant, then they're allowed to search. And number three would be some kind of extreme circumstance, like if the police heard some individual in jeopardy, or who was facing bodily harm, or if the police heard someone about to destroy evidence. Then that's what we call extenuating circumstances that police can then jump in and just stop the person from harming someone else or stop the person from destroying evidence. So probable cause is a standard in the criminal context where police have to be pretty darn certain that a crime has been committed, upwards of in the 80 to 90% range.
Now, how do you know if a police officer is 90% sure?
That's what
their discretion again.
Correct. It's their discretion, and it's difficult because there's no, human beings are not robots, and so we can't look at scale, and we're just sort of depending upon what the officer's testimony is later on as to what he observed and based on his experience and his training, what led him to be so certain. But that is something that's often challenged in court cases, is saying, based on these circumstances, officer, you should not have been this certain, and there was not probable cause.
Would it be enough? So sometimes people say, well, the officer might say, can I search your car? And you say no, and the officer says, well, only a guilty person would say no. Is that probable cause? Is that reasonable?
So no, that's not probable cause, and that's not reasonable suspicion, because if you decline to allow a police officer to search your car, effectively what you're doing is you're exercising your Fourth Amendment right. And so the police are not allowed to use that against you. It's actually similar to during a criminal trial, defendants have the right to not testify. They have the right to sit silent, exactly. And years ago, sometimes the prosecution in their closing argument would say things like, he didn't even testify. That shows you he's guilty. If an innocent person would have testified, and now the rule is the prosecution's not allowed to say that, because again, what they're by saying that they're using it against you when you invoke your rights.
Like there might be a reasonable way for you to just say, I don't want a police officer going through my car. I'm not guilty, but I don't.
Correct. Absolutely. There could be many, many reasons why an entirely innocent person does not want a police officer searching their vehicle.
Okay, well, how about this, Adam? Can I give partial consent? Meaning, I get pulled over, a cop says, I would like to search your car. I say, yes, officer, you can search everything except the glove box.
Yes, absolutely. Partial consent is allowed. You can tell the officer, limitations on what he's allowed to search and what he's not. And if the officer agrees to that, obviously they could say, forget it, I don't want to search at all. But if they want to search within those limitations, they have the right to. You could say you can search everything but the glove box. The other thing is you can revoke consent at once it's given. So you can give an officer permission to search the car, and then halfway through the car search, if you say, you know what, I've changed my mind, I revoke consent, consent's revoked, and they have to stop at that point.
Wow.
Of course, anything they have found up till that point they can use, but at that point, if consent is revoked, they have to stop.
Interesting. Very interesting. Okay, well, what if they are looking for a weapon? Maybe they're in your house, you've given them consent, or maybe they have a warrant. Let's just say whatever they're doing in the house is legal at the time, but the warrant is saying we're searching for a weapon, but then they find a bag of illegal substance, a bag of, I don't know, cocaine. Do they have to get a separate warrant on that, or can they act on the new evidence that they find?
They can act on the new evidence that they find, and that's actually called the plain sight doctrine.
Okay.
So let's say I have a warrant to search for a handgun, okay, and I'm searching your house, and I open up this drawer to see if the handgun is in there that I have this warrant to find, and when I open up the drawer, I find this bag of cocaine that Mr. Lindquist referenced. I, at that point, as the officer, can act on that because I had the legal right to be in the drawer, so to speak. The warrant for the gun allowed me to legally search the drawer, and in my act of legally searching the drawer, I found this other illegal substance, and so I'm allowed to act on it. And I do not need to go back and get another warrant. In addition to the plain sight doctrine, there's also something called plain touch, where, again, similar circumstance, let's say an officer is searching for a handgun and he's reaching up to the top shelf of a closet and he's patting down the towels and he feels, he's looking for a handgun, but he feels something that feels like powder. So, and by his training and experience, he thinks that's cocaine. Plain touch goes along with plain sight. He had the legal right to be up there looking for the gun. He innocently found the drugs while he was up there, and therefore he can act on that and does not need to go back and get another warrant.
Let's make this a little trickier. Let's say a tuba was stolen. In case you're not a band student and you don't know what a tuba is a very large instrument. Let's say a tuba is stolen. They have good reason to believe that Mr. Lindquist stole the tuba. I would never do that. But let's say they have reason to believe that, and they have the warrant to search my house for a tuba. And then they start going through my drawers, like the cabinet drawer that I would fit, paper files in this big. Would that be a legal search for them to search in there?
So generally, no. Generally, a search must be narrowly tailored to sort of the goal of the search. In this case, it'd be finding the tuba. So if the police were searching for a stolen tuba, they would be limited to searching in locations where the tuba could reasonably be found. So that might include, in a closet, in a garage, under a bed, in a crawl space, but it's not going to include in a desk drawer because tubas are too large. Obviously, it would not fit in that desk drawer. And so if the police officers, when searching for the tuba, are going through your desk drawers, they're basically just going on a fishing expedition at that point, trying to find something. And that's why it's not allowed. So the general rule is, if you're looking for the tuba, you can't go in these spaces that are way too small to ever have a tuba concealed therein.
It's so interesting to me that the Fourth Amendment is literally one sentence long, and yet all these questions come up, and it's, well, what would the founders say, and what do the judges say, and how do we interpret that? And yet all these rulings based on court cases are viewed as law. That's case law. That's the Fourth Amendment protection, even though the Fourth Amendment is no unreasonable search and seizure. What does that mean? And this is what we've been figuring out. Now, here's the famous case that I've told you since day one in the class. Knock at the door. Dun, 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 dun. Police. Okay, open the door. It's my wife and my home. My wife is very nice. Mr. Lindquist, not so much. My wife opens the door, and the police say, hey, can we search the place? No warrant. They're just asking for consent. My wife says, well, gee, absolutely, come on in. Mr. Lindquist says, you can't come in, get out. One yes, one no. Can they come in?
The answer is no. And it's actually a very interesting case. The facts of it are very similar to what Mr. Lindquist just said. And the court, this was addressed by the United States Supreme Court, and in addressing this issue, the court ruled that societal norms would dictate that if someone received one yes and one no at the front door, they'd probably not come in.
So if you were coming over and my wife said yes, come on in, and I said, Adam, get out, you probably
would get out.
Okay.
I probably would not come in over your objection. And so the court said that essentially the police should be held to the same standard as others in regard to these societal norms, where when one party says yes and the other party says no, the person who's coming over probably follows the objector and probably does not come in. So in a case where one person who owns the house says yes, the other person who owns the house says no, the no controls.
What if the police are like, oh, okay, well, here's what we got to do. We got to arrest that guy who said no. And they arrest me, put me in handcuffs, take me off. Then they ask the question again, and my wife says, yes, come on in.
So that's it's a very interesting sort of twist and sort of a hybrid on that situation we just discussed. And there was a United States Supreme Court case called Fernandez v. California that addressed this exact situation. And so the rule is that if the police have a reason to arrest you, they can, in fact, arrest you and remove you from the scene. And then once you're gone, if your wife is there and she allows the search, you're not there to object to the search, then the police can conduct the search, even though you would have objected had you been there. In that case, Fernandez was arrested by the police. While he was gone, his girlfriend consented to a search of his apartment, and they found evidence against him. He said, well, hold on a minute, I would have objected to it, but you arrested me. The only reason why I wasn't there to object to it was because you took me away.
No.
And the police response to that was, or the court's response to that was, well, we had reason to arrest you, and that's why it was okay. So to be clear, the police can't arrest you, the police cannot arrest you just to remove you so you don't object to the search. So they have to have some justifiable reason to arrest you. It cannot be just to stop you from objecting. But if they have a reason to arrest you and they do that, then whoever's left at the scene can consent to the search, and since you're not there, you won't be able to stop it.
Okay, well, let's take it a little bit further. I know we're getting in the weeds on this Fourth Amendment some more, but I find it so interesting. So let's say spring break's coming up. I'm going to go down to Florida, and let's say I have somebody dog sitting, house sitting for me, and police come over, knock, knock, knock. My house sitter opens up the door, and the police say, hey, can we search the place? And the house sitter, who doesn't even own the place, can they consent to a search?
Yeah, that's a really interesting question. So that deals with an issue called apparent authority. And so the house sitter, it's going to depend on what she conveys to the police at the time they come over. Now, when the police come over and they say, hey, can we search the house? If the house sitter simply says, sure, go ahead, and it appears to the police like she's an owner, it appears to the police like she has the authority to consent, then they are allowed to consent. And then they are allowed to go in and search the home.
But if she says, hey, well, I'm the house sitter, but I don't care, but I'm a house sitter.
Correct. Then the police are not allowed to search. If the house sitter says, well, I don't live here, I don't own the place, but I don't mind if you search, then it's clear to the police that they do not have an owner's consent. But if it looks, but if she leaves that information out and she just says, sure, go ahead and search, and the police say, well, we thought she was the owner, how are we supposed to know? Then they're allowed to rely on her apparent authority, and they're allowed to conduct the search.
So be careful who you have house sit, in other words.
Correct. No one who will consent to a search.
Wow. Okay. Well, geez, we're coming towards the end. I guess, for you guys, because you're high school students thinking about going to college, does the Fourth Amendment protect you in a college dorm room? Do I have any legal protection? I don't own the place. The school owns the place, so it's not quite like being here at the school with your locker, because you do live there, but you don't have any ownership to that place. You're just paying for your dorm room. What are the search protections like there in a college dorm room?
So those who reside in a college dorm room do have Fourth Amendment protections to that space. And it's similar to what you'd have in an apartment or another leased or rented space, which is that if it's your domicile, it's where you primarily reside, you essentially have the same protections as you would in the bedroom of your home. So the police still would need a warrant before searching your dorm room, and it would apply the same rules that we've discussed. The warrant would have to be narrowly tailored. They'd have to stick to only locations where what they're looking for could be found, and all of that would still apply.
Well, how would this same case relate to an apartment where you had roommates had each separate rooms?
It's a good question. So let's take a situation like Mr. Lindquist just said, where you've got 4 roommates. Each roommate has a bedroom. They're living in an apartment, and there's in addition to having their own bedrooms, there's common areas. There's a common kitchen, a common living room, for example. So under that scenario, any one of the roommates can consent to their own bedroom being searched as well as the common areas. So if I'm one of the 4 roommates, I can consent to the police searching my bedroom. I can consent to them searching the kitchen or the living room or whatever other common areas there may be. However, I cannot consent to a search of my roommate's bedroom. So essentially, space that is universally or exclusively yours, your roommate is not allowed to consent to a search of that. However, space that is shared with the roommate is allowed to consent to a search of the shared common space.
Well, that's a lot, Adam. That's a lot we've just covered. A lot of ground. I hope you found it interesting. So much nuance to the Fourth Amendment. So much nuance to the First Amendment, which is why we were able to spend, 2 entire class periods talking about just those 2 amendments. And, we didn't even get into all of it either. I mean, the First Amendment has 5 freedoms. RSPAP, religion, speech, press, assembly, petition. We just focused on speech and student speech and online speech. And now we've talked about search cases. So obviously this stuff is interesting to me and to some of you who've asked, what are my rights? I have rights. What are they? And how do they determine that? Now we've seen that it's the judicial branch's role who's made this a lot clearer. Okay, unreasonable search means this. Free speech means this. Adam, anything you'd like to add before we close out the video?
I would like to simply say again, thank you very much to Mr. Lindquist for having me into his wonderful class. Thank you to the students. You guys were great, very engaged, and you asked great questions. I was really, really impressed, and it was a pleasure meeting everyone.
Excellent. Adam, appreciate it.
Thank you, sir.
Till next time, hey, great to be gold.